This is case number 22-646. John Sorgenfrey and Deanna Sorgenfrey. Am I getting that right?
That's correct.
Oh, good. The Safe Point Insurance Company. All right, counsel, whenever you're ready.
Good morning. May it please the court. Matthew Strubler for the appellants. I'll preserve the 5 minutes for rebuttal.
Very well.
And in this case, the trial court committed reversible error by granting directed verdict based on an exclusion that was not pled as an affirmative defense. As this court held back in 2002, St. Paul versus Coucher, it's reversible error when a insurer fails to plead an exclusion as an affirmative defense. And all of the ways or arguments that the Safe Point has made to oppose that have been recently addressed by this court. That includes this court's decision in State Farm versus Davis, as well as Saavedra versus Universal. And the undeniable fact is that it is clear that in order for an insurer to raise an exclusion, it has to be pled as an affirmative defense. In this case, the court ended up...
Counsel, let me ask you, and I know you knew we were going to go there, but you pleaded in the amended complaint that, in fact, there was a denial letter from Safe Point, and that denial letter is appended to the complaint, and by operation of the rule, that is subsumed within the complaint. So basically, the exact language of this denial is captured in your client's pleading. So why is that not a good enough thing here?
Yeah, a few things. First, we cite cases which makes it clear a knowledge of a potential defense doesn't put a party on notice that they have to defend against it. And yes, it's true that they moved and we had to file an amended complaint. We attached a denial letter. It's the same way as in every single case. You have to attach a copy of the insurance policy. And yes, that general rule that becomes incorporated within the pleading does exist, but that doesn't mean that just because the policy is attached to the complaint that an insurer can raise every single exclusion that's attached to it without asserting as affirmative defense. And the same exact true is with the denial letter. In this case, they had an abundance of exclusions in their denial letter. They had several that they had raised, and if they wanted to pick one of those to actually pursue as an affirmative defense, the law is clear that they had to do so. And
what about the argument that you were anticipating the affirmative defense, and by virtue of anticipating it and including it, they didn't have to raise it? What do you do with that? And I know they cited it, but Flauger, second pleadings, section 61, the effect of the plaintiff's anticipating and pleading a defense in his complaint is to relieve the defendant from the necessity of raising that defense in the pleading. So what would you say with that truism? Why does that not apply here?
Yeah, kind of a two-part reasons. First is, as I indicated, and we cite to the Dersalo Industries. That's a case from the 4th, 857 SO.2D925. It also cites to a case, Boguson versus State Farm. And in those cases, that exact issue came up, and they explained that knowledge about a potential defense doesn't put a party on notice that they must defend it. So that's the first aspect of it. Secondly, if you look at the case that they're citing it to, and we addressed it in detail in our reply, the case that they are citing to is the Boer case. And the Boer case is a case that came out in 1964. And that's what they are relying on. In the Boer case from 1964, that they are relying on, that case was addressed by this court subsequently. And when this court subsequently addressed that in the St. Paul versus Coucher case, it specifically said that, well, if it's an affirmative defense and it's an insurer that's seeking exclusion, then they have to raise it. And the Boer case, in addition to that, that was a case where the plaintiff had sought declaratory judgment action. So they filed a lawsuit, and the lawsuit was saying, asking the court to interpret a 52-week provision. And that's what the entire case was about. And so in Boer, which is the case they're relying on that you just referenced, number one, it was before this court found subsequently that an affirmative defense exclusion must be raised. And two, in that case, trial judge, you've dealt with a declaratory judgment. The issue in that case was the plaintiff filed a lawsuit saying there's this 52-week provision. We think it's ambiguous. We're asking the court to interpret it. And because that was raised as an issue, the court said, well, it didn't matter if they raised it as affirmative defense. That's what the case was all about.
So even ceding all of that, counsel, their fallback is, well, this was tried by consent, and there was never an objection in front of the trial judge that you have, the SafePoint has exceeded the scope of their pleading. So why was this not tried by consent?
Two reasons, which I could walk you through, and they're detailed in our reply, but there's two things that have to happen for it to possibly be tried by consent. First, there'd have to be a motion to amend. It's very clear on that. There was never a motion to amend to conform to pleadings. Instead, what they did was they said, Judge, that they should have been aware of this. It came up in discovery, and I let the judge know, well, Judge, the case law is very clear. That's not true. And then in addition to that, it was not.
I read that, counsel, and I read the cases you cited, but the rule, as I read it, doesn't say that. And I just would refer you to 1190B. The second sentence says, talking about amending the pleading, such amendment of the pleadings as may be necessary to cause them to conform to the evidence and to raise these issues may be made upon motion of any party at any time, even after judgment, but failure so to amend shall not affect the result of the trial. Actually, former Judge Padovano in his treatise deals with that and says that the better practice is to amend, but the rule doesn't require it. So what do you do with that language of the rule?
Yep, so I would just point to this court's recent decision in Davis where that exact issue came up. And in Davis, this court said it can't possibly be found, a party can't possibly have been found to consented if an objection was made. And quickly, just to kind of line up, you can see from the record in the trial transcript, the very first time this exclusion was ever raised, that's on trial transcript pages 613 to 614, it was first raised after we rested. So through our case, this whole issue of whether it was a wind-created opening or not was never an issue in the case at all. It was brought up for the first time after we rested. And when we rested, in response to that, I explained, and we had a memorandum, we cited this court's Savager case, and we told the court that they can't possibly rely on that defense because it was never raised as an affirmative defense. We objected. And we actually even later on moved for a directed verdict as to that. So it can't be tried by consent because it was never raised during our case. And as I point out, if you follow along on the transcript, and in fact, the terms opening, that was never spoken by anybody even in the defense. It only came up twice, and that's on pages 686 of the trial transcript where the very last question, SafePoint's trial counsel asked a long leading question from their expert to try to indicate that there was no wind-created opening. And before that even happened, we already detailed in court and explained to the trial court that they can't possibly rely on the defense, that exclusion, because it wasn't pled. So as this case held last year in Davis, if a party objected to it, they can't possibly be found to have tried it by consent. And in this case, we objected to it. They hadn't raised any defenses. First time they brought it up was when they moved directed verdict, and we said, Judge, that's not a defense, that's never been pled. In fact, they tried it for an array of exclusions that had never been pled.
Well, moving past that issue, was there evidence at this trial of a wind-created opening that let in moisture that caused damage to your client's property?
We never addressed it directly in our case because it wasn't a defense. The way it would work, and I gave some examples of the evidence we would have put on if it was a defense, is they're supposed to plead it as a defense. We replied to their affirmative defenses they actually pled. They would have to plead it as an exclusion. And then in our reply, we would plead no, that there was a wind-created opening.
So, and I want you to answer the question. I don't want to put words in your mouth. So you're telling me during your case there was no such evidence at trial?
There wasn't direct evidence. We had enough just because it's kind of related issue. So I give some examples. We had an adjuster who had given a depot. We had an engineer. We didn't call those people. Court said it was cumulative. We didn't oppose it because there was no exclusion to address it. What we do, our second argument is basically we're saying, we didn't put in direct evidence because it wasn't a defense that was at issue in the case. There was related issues because this was a as we talk about, this was a property that was located right on the ocean that was hit by a hurricane, which had substantial damage, and we had evidence from one of the experts who said, in his opinion, the water got into the units through two things, a soffit that was on the upper area, blown out by wind, or there was a deck. And if you look at the appendix, we put about 100 pages of materials in our appendix to the initial brief to really give this court a flavor of what we're talking about. And you can see it's very clear. It's a property right on the ocean. It had a deck in between the bottom unit, Unit D, and the top unit, Unit C. And we had expert testimony where Mr. Hostetler, which we go in detail, and his testimony that the jury did hear was that that deck was racked by high winds and things were pulled apart, and that is what allowed the water to enter Unit C and go down into Unit D. So,
What do you make of the interrogatory answer? I've got the interrogatory in front of me. These came from your clients, but the question is, identify which policy provisions you rely on to support your contention that there is no coverage for the subject loss as a result of Hurricane Matthew. That seems like a very specific question. And then the answer actually has this coverage provision saying we do not insure loss where the opening is not caused by the peril. So what did you make of this interrogatory answer?
Yep. So what we made of that was, like this case found, or this court found in the Davis case, that affirmative defense can't be raised in discovery. It can't be raised in outside materials. Certain things can come up as they do in various ways. There's many defenses that they could have raised, but they decided in their pleadings is what they're bound by. According to their pleadings, they were pursuing condition defenses, saying our client did not comply with conditions precedent. Those are the defenses.
Let me ask you this. I mean, you attached the Exhibit B, which was their denial letter, and you allege there are no exclusions that operate to exclude coverage for the claim. The exclusions cited in Exhibit B, which was their denial letter, do not apply to the claim. Okay, then they file an answer to that and say, we admit that a copy of the denial letter is attached to the amended complaint as Exhibit B. However, we deny the allegation in paragraph 9 that the exclusions do not apply. And then they have a separate affirmative defense that said that the damages are excluded under the clear and unambiguous terms of the policy. And I agree that if you made a motion for more definite statement or a motion to strike, it would be appropriate for the trial judge to say, be more specific. But combining those three things, the denial letter, their answer saying, hey, we deny that these exclusions cited in your complaint do not apply, and then adding the affirmative defense that there's exclusions that prevent the claim, why wouldn't those combined give you notice of their defense?
Yep, so two things to that. So first, if you look at the denial letter, you'll see there's no allegation of a failure to comply with conditions. But as their affirmative defenses, they decided that's the defenses they were going to raise. And that's what they are bound by. That's what they decided to do. So on that point, it shows, they weren't in their denial letter, but they wanted to make their case about conditions, and that's what they did, and that's what they are bound by. Secondly, in terms of the definite statement, that exact argument was raised by the insurer in Saavedra versus Universal. That's this court's case from last year. And that exact argument was made. In that case, it went to summary judgment, and the insurer, summary judgment was entered in their favor. And this court reversed because the summary judgment was based on a condition that wasn't specifically raised as an affirmative defense. The insurer in that case argued that the insurer, the homeowner, should have moved for a more definite statement. And this court rejected that exact point in Saavedra versus Universal. So that's already been addressed by this court, and it's the exact same scenario here.
In that case, though, was the denial letter appended to the complaint?
I don't know if it was, I can't answer that.
Isn't that a game changer here, that the fact that this is embedded in your client's pleading and subsumed within the pleading? And matter of fact, I know you know this, if it contradicts what's alleged in the pleading, the denial letter wins the day. I mean, that's Flavel and a long line of, Flaudel and a long line of Florida Supreme Court cases. So what we have here is a denial letter that is indelibly part of this record. So I'm just having difficulty understanding, your claim in essence is it was not pleaded, but your client pleaded it. That's the difficulty I'm having here.
Yeah, so a plaintiff can't plead defenses. That's up to the defense to do. They elect what defenses they want to take the burden on. And that's what happened here. They elected to prove, to cite condition defenses. And it's the exact same as Saavedra, because in Saavedra, they just generally said, you didn't comply with conditions, so there's no coverage. In this case, they said there's exclusions that apply, that there's no coverage. And they had to specifically assert them. So Saavedra is directly on point. In this case, if they wanted to pursue one of the various exclusions that were in the denial letter, they were required to do so. And as we point out, their denial letter, they don't, if you look at the detail of it, they only reference there not being a wind-created opening in relation to personal property, coverage C. That was a minute issue in the case. What the case was about was the building. And
Well, I did see that, counsel. But if you look up higher, under coverage A, I see a more general statement. I'm looking at the interrogatory now, but it says, however, we do not insure loss caused by rain, snow, sleet, sand, or dust to the interior of a building unless a covered peril first damages the building, causing an opening in the roof or wall. So it looks like they did have that in the denial letter.
The denial letter, they only raise the no opening. They only state that there's no opening and relates to personal property. And you could look, we've made that clear in our brief there. That's the only portion where they allege that. And that goes to show if they want to assert a defense, they are required to do it. They can't just rely on other documents. And that's why this court in Davis said exactly that. That even in that case, even though it was the other way, the plaintiff, but even though the defense was aware of damages and that the plaintiff was claiming it, was aware of it in discovery, that didn't matter because the only thing that matters is that it's pled as an affirmative defense.
Davis, it wasn't pled at all. The aggravation claim was not pled in the complaint at all. This seems a little not as clear cut. There are pleadings addressing
Well, the point I'm making,
exclusion.
and I know that was you were on that panel, Judge, is that in that case they were aware of it in discovery. They knew all about it in discovery. Those were an aspect of damages.
That was the deciding vote. Go ahead.
Yeah, but the plaintiff, even though the defense was aware of those damages, even though the defense received those damages at discovery, they couldn't pursue them because they did not plead them in their complaint. And the same is here. Even if the plaintiff was aware that they may or may not be pursuing exclusions, then in this case, it doesn't matter unless they pled it in their answer, which they did not do. So for those reasons.
You're 2:30 and you got 2:30 left in rebuttal, so.
Yep. I'll stop now and just for that reason, they're bound by their answer, and in their answer, undeniably they did not plead the exclusion.
All right, thank you, counsel.
Good morning. Patrick Chidneys for the Appalachia Safe Point Insurance Company. And I'll start very quickly by just pointing a couple of issues out. The denial letter does include the rain damage exclusion. It's at record 309. Saavedra, which was cited as a conditions case, a different rule, but in that case, Judge Evander, you're right, it was not pleaded, that trying to negate a defense in the Saavedra case. The first thing I'd like to point out on the pleading.
You agree, though, it would have been better practice for you to have listed those affirmative defenses with specificity.
The thing is this, I don't think that's necessarily the case in an unusual case like this. And so we're not relying only on...
Would that be the better practice to raise it as an affirmative defense?
As an appellate lawyer, I would do it 6 times. I would put in every single thing I could. Certainly it would have been clear we wouldn't be seeing this argument. But the point is that...
So that would be better for you.
It would probably be best practice for everybody to plead something as many times as they can in every possible opportunity. But the thing is, a unique situation like this, where someone preemptively tries to negate a defense, has been addressed not just in Boer, but by the Florida Supreme Court in the Huff case. We cite to that, and the court says that it may be unusual and the language may be surplusage, but the defendant has no obligation to then state another pleading. And so that's not just from the Boer case, but also from the Florida Supreme Court, which has addressed this precise issue. And that distinction that was raised in counsel's argument between Boer and Coucher actually underscores this point. The Boer case was a policy dispute where someone sought declaratory relief, and they, among other relief, and wanted to say that this 52-week expense provision didn't apply. Well, the court in Boer said, let's assume that's an affirmative defense. Because you put it in the complaint, you don't have to bring it up now. The Coucher court just said the same thing, that in the Coucher case, there was not a preemptive attempt to negate a defense, so it didn't apply. And the last point here is that all of the cases in the reply cited for this premise, you got to plead defenses. None of them involve a plaintiff preemptively pleading the defense. And this was not merely appended to the complaint. So this is not a situation where it's just in the factual background. If you read paragraph 9 of the amended complaint, it actually says SafePoint breached the policy by asserting these. So in theory, that's a separate kind of breach. In an insurance party, a first-party case, you see this in Empire Pro. It's also said in the reply brief. The plaintiff's only obligation is to show a loss in the policy period. Then the burden goes over to the insurance company to plead exclusions. Then there's an exception, goes back to the insurer.
And what Mr. Struble is saying, that, well, the problem here with that concept is that I presented my case in chief with the understanding that this exception or exclusion was not applicable because you did not specifically plead it, and now it's become the tail that wags the dog, and that's pretty unfair. That I don't want to put words in his mouth, but he seemed to, in response to Judge Jay's question, say, well, there really is no evidence of the hole that was created by the hurricane that led to the rain coming in, that led to the damage, that led to the claim, because I didn't think I needed to do that because the exclusion wasn't pled. So
Sure.
This is unfair, and we want to have a do-over. I know this is somewhat non-technical or non-legal terms, but in essence, that's what he's saying, right?
Sure.
Why
So-
that sounds, the due process thing, I've heard about that somewhere, that seems like a problem, isn't it?
Absolutely. So setting aside the fact that they've teed this up, they've alleged we breached the contract by asserting these specific exclusions. So setting aside Huff and the case law from Florida Supreme Court saying that we don't have an obligation that they've placed it at issue, we don't have an obligation to plead it. This was clearly tried by consent, and I think that their argument actually cuts more against them, particularly after the DV, what happened in SafePoint's case in chief, where the court's correct. There was not a single objection to any of the testimony. So let's just think about that logically from the trial court standpoint, from counsel's standpoint. Let's say that the last question of their case in chief, they ask our expert how water got into the property. Again, in a first-party case, that has nothing to do with the plaintiff's initial burden. It's just lost during policy period. So we could argue that last question they ask of Mr. Kester via deposition, our expert, they said, isn't it possible water could have gone up and under the soffit and gone into the property? Let's say that doesn't have anything to do with the no opening exclusion, which we would argue it does. By the point of the DV, so after the directed verdict, they know where we're going. That it has been very clear what we're going to argue. It's not like we waited till the second DV or we didn't assert this till the close of our case in chief. At the end of the directed verdict argument, there is no doubt in anybody's mind where SafePoint intends to take this case. After that, this is a question at transcript 695. I'll cut to the important part. Did you see any evidence whatsoever that based upon your training and expertise, qualifications, and most importantly, observations, did you see any evidence either in Unit C or Unit D that a storm, specifically Hurricane Matthew, may have even been a tropical storm, particular storm, created an opening in either the roof or the building envelope such that allowed the intrusion of water to that interior? Did you see any evidence of that? No. Now, the Sorgenfries, they did not object to any of this testimony. Instead, on cross, they started asking him about whether the storm could have damaged the soffit and water could have come in through the soffit. That's at transcript 722. And then later at transcript 730, wouldn't that have been a good place to allow rainwater to get in? So they're asking him questions about how water entered the interior. But I think the most important testimony is at transcript 741 to 42, where, and this is so important because there was an objection, but it was leading. It was not on exceeding the scope of the pleading. So, and one last question, do you maintain your opinion that there was absolutely no evidence of any storm-created opening allowing water intrusion to this property? Answer, there was no evidence at the time of my inspection. Question, or to this day, based on everything you've seen, correct? Objection, the court sustains it as leading. Question, or no evidence of that? Answer, yes. Question, right? Answer, there was no evidence as of today of any storm-created breaches or openings in the walls or the roof. Now, at this point, there's been no objection, but
Counsel, I think I know the answer to this. Was there ever a request of the trial judge to allow them to reopen the evidence on their side and to put in Mr. Perry's testimony, for example? Did that ever happen here?
no, Your Honor, and that is a waiver of the argument that there was additional testimony that they could have presented. There was no argument. They accepted this, tried to challenge it on cross, and made no effort whatsoever to open a rebuttal case.
Let me ask you this, backing up even before the evidence, an opening statement, plaintiff's counsel said they have the burden of proof exclusions, and they're not going to have any witnesses to testify in support of that. in defense opening statement, was there any mention of the exclusions that the defense intended to rely on?
To my knowledge, there's not a description of this specific exclusion in the defense opening statement. So again, I do think that the plaintiffs put it at issue in their complaint, and it actually sued us for breach based on those exclusions, asserting the exclusions, which is conceptually different. So I think it was at issue in their case. They recognized that by saying there are going to be no exclusions. The only exclusions, if you read the pleadings, and Judge Evander, I think you're right, if you hold these pleadings side by side, yes, affirmative defense number 4 that just says exclusions apply on its face in a vacuum may not be sufficient, should be stricken, should be subject to a more definite statement. But if you sat there and you put the two beside each other and you read 1, 1, 2, 2, got down to the last one, and I asked you what exclusions are you talking about, you go back to 8 and 9 and say, actually, we've got them specified right here. You've said they don't apply. You've said, yes, they do. I know what exclusions you're talking about, at least on the face of the two documents. So I think they placed it at issue.
So Judge Evander would be able to figure that out?
I believe so. I believe so, Your Honor. Moving to the substance, I think we've heard that there is no direct evidence of an opening. We discuss this in detail in the brief, but just a general sort of high-level analysis. A good case to compare to a lot of the other cases is the Gajwani case out of the 3rd, which there was a strong storm, forced water through windows and doors, and seeped through cracks in the stucco. That kind of event is not within the scope of the exception to this exclusion. In a strong storm event, you would expect water or wind might go through something that's normally watertight, but that's not a storm-created opening. There's no evidence of a storm-created opening in this case, which leads to the final point we've raised, which is that if you're going to assume, as they've said today in argument, that this is circumstantial evidence, they've got to make a next circumstantial argument to prevail. They've got to show that there was interior water damage attributable that came through this opening. Because remember, the exclusion says we don't insure for loss by rain unless a covered peril damages the building, creating an opening in a wall or roof, and rain goes through that opening. So this came up in a case, I'm sure the court has reviewed it, but New South Communications out of the 11th Circuit, where someone filed a 327-page report and a Hurricane Irma claim in a commercial building in the Keys, and the expert said there were plenty of storm-created openings, they caused all this interior damage, listed the categories, but never linked the supposed opening to any particular interior damage. The same results here. They're seeking $80,000 for both units, and they aren't linking it to any particular opening. So to assume there's an opening and then assume there was damage stacks the inferences. So if there are no further questions from the court today, I would ask that the court affirm.
Okay, thank you, counsel. All right, Mr. Struble, the clock says 2:17. So.
Okay, thank you. So the complaints on the record, 252, paragraph 6, in terms of the allegation, plaintiff alleges that there was damage during the policy period. That's plaintiff's burden. It does say no exclusions that apply. The defense has the burden to prove an exclusion. And if they wanted to prove that an exclusion applied to the claim, it was their burden to pick an exclusion, cite it, and raise it as an affirmative defense. If you look at the denial letter, there's a dozen separate exclusions that are in there. If they wanted to elect to proceed with one of those, it had to be pled as affirmative defense. And in the case, as the trial unfolded, it went forward. And the exclusion, the issue of an opening, was never spoken by anybody until on the record trial transcript, page 613. And this is after plaintiff's case was closed. This is after the defense moved for directive verdict on all their conditions defenses. After all of their directive verdict for their conditions defenses were denied, they started arguing exclusions for the very first time. And we pointed out to the court that they've raised no exclusions as affirmative defenses. And because of that, it would be improper for the court to consider those. So it can't possibly have tried by consent. It was not pled, and it was the defendant's burden to plead and prove an exclusion. That's their burden. And as this court has held, it's per se reversible error to allow an affirmative defense to be raised by documents outside of the pleadings. So for those reasons, we ask that you reverse.
Okay.
Thank you.
Counsel. All right, that will conclude our oral argument session today.
Mr. Struble, wish you and your